Beautiful, beautiful people. Welcome back. So, in case you were wondering, well, why does all these courts, why do all these courts categorize documents as one thing or the other? Why is it that even if I put in an affidavit, they categorize it as a motion or something else? The simple answer to that is there are categories to which each document are classified as. It's a form of filing system, basically. A filing system that has a tree, and each tree has roots to it. Generally, they call them motions or pleading. And then, depending on the stage of the proceeding, or depending on what occurred before you put your document in, there's a file or a main tree that your document will go under. It's either an answer, a counterclaim, a complaint, or a reply. We'll show it on a federal level, which is the uniform one in just 2 other states. But know that it's uniform when it comes to civil proceedings and in criminal. Just keep in mind, each state, just like federal level, has criminal rules of procedure just as much as they have civil procedure. And then there's appellate rules, and then there are Supreme Court rules. So if you want to appeal, there's a procedure for that. If you're in a criminal matter, there's a procedure for that. If you're in a civil matter, there's a procedure for that. But in a civil and criminal matter, they have similar categories of how paperwork are categorized. So we'll show it on the federal and 2 state levels. Rule 7, pleadings allowed, form of motions and other papers. Meaning the form in which substantive rights, meaning the form, the vehicle to which certain things will be communicated or enforced, called motions, and other papers, meaning whatever it is that you put in, whatever you name it, there's a form to it. And that form is the filing system and the tree to which they're going to that pleadings are basically any document, any paper that you put in, whether it's exhibits, whether it's judicial notice, whether it's an affidavit, whether it's a demand for something, whether it's a request for something, whether it's a transcript, whatever it is, they're all considered pleading. But just to be sure, what is a pleading? Pleading definition. Pleading is the beginning stage of a lawsuit in which parties formally submit their claims and defenses. The beginning of a lawsuit, meaning anything outside of settlement, anything outside the trial stages, anything that you put in is called pleading, where someone makes a claim and someone says no, that claim is wrong, aka defenses. Overview. The plaintiff submits a complaint stating the cause of action. The defendant submits an answer stating his or her defenses and denials. The defendant may also submit a counterclaim stating the cause of action against the plaintiff. Pleadings provide notice to the defendant that a lawsuit has been instituted concerning a specific controversy or controversies. It also provides notice to the plaintiff of the defendant's intentions with regard to the suit. Pleadings are part of a large category. Pleadings are part of a large category. In other words, a filing system, a tree that other things branch out of. Meaning pleadings can be a variety and a number of things. And this term pleadings, whenever you read in any quote legal documents, they just loosely use it to refer to literally, word for word, things that you put on pen and paper, no matter what form it takes, or no matter what substance it bears. Pleadings are part of a larger category of procedural rules. In state court, pleadings are generally governed by state procedural rules. For example, see blah, blah, blah. the civil codes of California. Federal court pleadings are generally governed by federal rules of civil procedure, particularly by Rules 7 to 16, which is where we started, which brings us back to Rule 7. Pleading. Only these pleadings, in other words, only these documents are allowed. Remember, we wanted to note that why do they categorize your document as one thing or the other? You can call it one thing that makes sense to you and does make sense by operation of law, aka the procedural due process, aka the legal stuff, which has its origin in the lawful right that you're entertaining in that paper. You can call it one thing or the other, but their filing system and the way they categorize it is called pleadings. In other words, anything you put in. And each pleadings have category. One is called a complaint. Another is called an answer. A complaint is how you initiate a suit on a civil level or a criminal level. On a side note, on a criminal level, if it's a capital crime, an indictment is required. If it involves the risk of jeopardy of human life, depending on the class of the crime, an indictment takes place with a grand jury or by information or complaint, aka something that says, hey, we have reasonable expectation that probable cause exists, and someone witnesses it in front of an acting judge, and a warrant is issued after that instead of a summons. A summons is civil cases. Criminals, they issue warrants. But nonetheless, a complaint exists, but they're derivatives of way to bring claims, which is a counterclaim or a cross-claim. But generally speaking, is a complaint and an answer. Those are the two main types of pleading. And then there are derivatives of those. Again, called the complete 23-minute video is posted on the Patreon page. Take care. Best of luck.